Welcome back to the Joe Miller Show, KON Hot Talk 1080 AM, 95.1 FM. This show is made possible by the McPherson Tax Defense Group, 1-800-BEAT-IRS, beatirs.com, BEAT-IRS, serving Alaskans, Americans since 1978 with 2 generations of tax defense attorneys. We're honored to have with us Colonel John Eidsmoe. He's a frequent lecturer, debater at colleges, university, churches, civics groups. He's been an attorney for 45 years, successfully litigated court cases involving First Amendment religious freedom, defended home education, Christian schools, championed the right of students and teachers in many different contexts to exercise freely their religious beliefs, and also served on that 10 Commandments legal defense team involving Judge Roy Moore in Alabama. He holds 5 degrees in law, theology, and political science, including 2 doctorates, a law degree from the University of Iowa, 1 in ministry from ORU, earned his master's of divinity from Lutheran Brethren Seminary, master's of arts degree in biblical studies. Colonel Eidsmoe, thank you for being on the Joe Miller Show. We look forward to hearing what you have to say about religious freedom and how it's under threat in this country.
Great to be with you.
I guess I shouldn't say we look forward to hearing about the threats, but it's a reality, isn't it?
Well, we need to hear about them, that's for sure, and they are becoming more and more a reality.
So you authored a brief, and this is interesting because there's a bit of an intersect with some work that Restoring Liberty did, our website. We called for recusal of Ginsburg and another justice with respect to the gay marriage decision. And we cited a brief, an amicus brief that had been filed with the Supreme Court that apparently you wrote or your group wrote, calling on recusal. Is this, I don't want to go into the whole recusal thing because we've talked about it ad nauseum on this program. And you have Supreme Court justices that go out there and conduct themselves in homosexual marriage ceremonies and opine on, under the Constitution they're marrying. Obviously, they shouldn't be sitting on a case that's not yet decided. But, do you view this decision, the Obergefell decision, as a legitimate decision as an attorney, or do you think it's illegitimate?
I think it's an illegitimate decision, and 2 primary reasons, as you brought out. The fact that it's a 5-4 majority, and the 5 votes were secured by bringing 2 justices aboard, Justice Ginsburg and Justice Kagan, who I've never in my 45 years of practicing law seen a case where the need for recusal was as obvious as it was here. And obviously the only reason they didn't recuse was that their votes were needed in order to swing the decision as it was. But the second reason would be that the decision has absolutely no foundation whatsoever in law or in the Constitution. As Justice Roberts said in his dissenting opinion, let's not kid ourselves, this is simply the desires of these 5 unelected lawyers. And for those reasons, and a number of others as well, but primarily for those, if there is ever a decision that deserves to be disregarded by the state Supreme Courts, by the state legislatures, by county clerks, probate judges, and others, this is it.
So is there precedence for that, where state courts have ignored the decisions of the U.S. Supreme Court and gotten away with it?
There certainly is, but it goes back quite a ways. I'm thinking particularly of the Dred Scott decision in which a divided U.S. Supreme Court said that the fugitive slave law was constitutional, and therefore people in free states like Wisconsin were obliged by the federal fugitive slaves law to capture blacks who had fled to their states and return them to their slave masters in the South. And the Wisconsin Supreme Court, like the Wisconsin legislature, simply announced, we're not going to follow that here. That decision is invalid in Wisconsin. And they were right in doing so. And we're seeing the same thing here now. And just as much basis for disregarding this as there was for disregarding that one.
So we talked about recusal. We talked about another issue relating as to why the Obergefell decision is, as you put it, illegitimate. Any other reasons why it's not the supreme law of the land?
I would say that Supreme Court decisions themselves are not law. The Constitution, Article 6, Section 2, says that the Constitution, laws passed by the Congress, and treaties are the supreme law of the land. It doesn't say court decisions are the supreme law of the land. And to say that they are is, I think, quite a stretch.
So I mean, we're talking about a principle that might be better described as the hierarchy of law. And you would probably describe the Ogerbefell decision as being case law. Where does case law fit on the hierarchy of law in your perspective?
In my opinion, it's down quite a ways because case law is only the interpretation of what one court says the law is. But we've got an interesting matter going on here in Alabama right now. And back in March, shortly after a federal judge struck down Alabama's Sanctity of Marriage Amendment, an amendment that our voters passed with 81% of the vote in 2006, this federal judge struck it down. The Alabama Supreme Court issued an order on behalf of the probate judges saying that that order was not binding on the judges of the state of Alabama. Rather, they were required to follow the Alabama Constitution, cited Johnson versus Williams and a number of Supreme Court decisions that say exactly that. Well, after Obergefell, now several probate judges and the Alabama Policy Council, a couple other groups, have now filed a motion with the Alabama Supreme Court to extend that order and keep it in effect, saying that Alabama probate judges are to disregard Obergefell and follow the Alabama Constitution. And we are waiting for the Alabama Supreme Court to rule on that. And if they do decide to extend the order, that could redefine the whole relationship between federal and state courts and even between federal and state governments. So we'll see what they decide, and it'll be a most interesting result either way.
Of course, the gay marriage decision specifically only had application to the parties that came before it. So with respect to its impact in Alabama, it should at least technically have none, right?
That's the way I would interpret it. Now, that's a disputed point. That's been disputed a long time, whether only parties are bound by a decision or whether all others similarly situated are likewise bound. I would take the position that the framers never intended that Supreme Court decisions or any court decisions be given the broad universal application that they've been given today.
Well, this is very interesting what's taking place in Alabama. I'd like to keep you on for another segment if possible. I'd like to talk a little bit about what's going on with Kim Davis. Also, of course, I'd like to hear what you think is going to happen in Alabama. Stay with us, The Joe Miller Show. Colonel John Eidsmoe, back after these messages. Welcome back to the Joe Miller Show, KON Hot Talk, 1080 AM, 95.1 FM. We have with us Colonel John Eidsmoe. He has 5 degrees in law, theology, political science. He worked with the Ten Commandments legal defense team out of Alabama, ordained pastor, been very active lecture circuit debater on religious freedom issues, particularly as they intersect with constitutional law. He's a constitutional attorney. Been an attorney for 45 years. He's going to be at the conference upcoming, Religious Liberties Conference in Des Moines, Iowa, November 6th and 7th. I mentioned this earlier in today's show and before. If you want to learn more about that conference, freedom2015.org. Again, freedom2015.org. There's a discount code if you type in Miller at your promo. And we also, later, sometime over the next several weeks, will be giving away a number of registrations for that conference. They expect over 2,000 people there, and speakers include GOP presidential candidates, Kelly Shackelford, Benham Brothers, etc. A lot of the folk you've heard on this program and more. And Colonel Eidsmoe will be there as well. Colonel, thank you for staying with us and talking about these important issues of religious liberties and their intersect with law.
And thank you.
So we were talking about Alabama and kind of how the controversy there is not over. That things are setting up for yet more conflict between the federal courts and the state courts. Tell us where we're at there and where you expect that to go.
On the motion that was filed before the Alabama Supreme Court, we are still waiting for a decision, and one could be entered any day. But we've got a couple of other interesting matters going on, too. One of them involves 2 gay men who went up to Massachusetts, went through a marriage ceremony in 2011, came back to live in Alabama, and after a few months, one of them was killed in an accident involving a UPS truck. The other then tried to collect his spousal share of the settlement for the estate and was told that he couldn't collect because Alabama did not recognize his marriage as being valid. Now that the Obergefell decision has come down, now they're trying to move ahead with that. Our argument on that is that there is nothing in the Obergefell decision that says it is to be applied retroactively. Now, there's another case in Mississippi, and this one I think is even more unforeseeable, even more interesting. It involved two lesbians who went to Massachusetts, got married, and came back to Mississippi, and then one of them decided to leave the relationship, left the lesbian lifestyle, fell in love with a man, married him. Now, with the Obergefell decision, the ex-spouse has now sued her and is saying that our lesbian marriage was valid and still is valid, therefore you can't be married to this man, and demanding property settlements and a number of things like that. All these are things that the court never foresaw when it entered its decision, and who knows how many other such things like this are going to come up.
So is she claiming bigamy?
Essentially, yes.
Oh, my word. So there are some standards that they're trying to apply.
Now, the interesting thing is, when the other one left the lesbian lifestyle, she looked at the possibility of divorce, and she was told that, no, Mississippi cannot give you a divorce because we can't divorce a marriage that we don't recognize as valid. And as far as going to Massachusetts, well, to go to Massachusetts, she'd have to establish a one-year residency in Massachusetts to file for divorce there. And so this is an unusual circumstance, but one that the court should have envisioned.
Well, it's a crazy world out there. I mean, that's idea that the Supreme Court can reach out there and just create any right it wants, and then to assume that there's going to be some sort of parameters that are later applied, like this idea that, okay, we can have a homosexual marriage, and yet we're still going to apply concepts like bigamy. Not that that happened in this case, but I'm just kind of extrapolating out to the future and how this may actually go down. In Alabama,
that's what's so weird about this whole thing. When you read Justice Kennedy's 5-4 opinion there in Obergefell, probably the key sentence of that opinion is where he says that the framers of the 14th Amendment did not give a definition of the word liberty because they couldn't envision what all it would include, and so they left it up to us to define its outer boundaries. And anyway, that is a license for a court to do anything at once. Thomas Jefferson said that that the Constitution would be a ball of wax in the hands of judges like that, and I'd say that's being generous. I'd say it's more like a ball of silly putty.
So let's move into what Kim Davis did. I mean, Kim Davis, of course, refused not a specific necessarily court order that impacted her, although some would argue it did. She, of course, is still continuing to say, hey, I'm not going to help facilitate the issuance of gay marriage certificates in Kentucky, although her deputy clerks are allowing it, and so therefore the federal judge, in his decision at least, releasing her from custody, said that that means that people's liberty to be married isn't going to be interfered with. Do you think what she did was right?
Absolutely. In fact, there are many who say that what she should have done in those circumstances is simply resign her position in protest. I would say that if she had resigned, likewise, if Chief Justice Moore had resigned from the Supreme Court over the Ten Commandments issue, they would be betraying the people that elected them. Under the doctrine of lesser magistrates, or interposition as you sometimes call it, when a higher magistrate like the U.S. Supreme Court or a federal judge begins to act in an extra-legal and tyrannical manner, it is the duty of lesser magistrates like state courts and state judges and county clerks and the like to interpose, that is, to stand between the people that they represent against the tyranny of the higher magistrate. You might say that if the higher magistrate has become disobedient against God, for the lower magistrate to simply follow what the higher magistrate says would make the lower magistrate complicit in this act of disobedience. I think she has a duty to stay on and a duty to resist. What they're trying to do in that case right now, of course, is they're trying to work out an accommodation where we could say that the law has a duty to accommodate those who have religious objections. That's fine insofar as it goes, but it doesn't go far enough. Rather, they need to recognize that this whole decision is illegitimate and it needs to be nullified.
Well, in fact, also, if you resign, you're just basically clearing the field. You're creating basically even more fertile ground for additional persecutorial type behavior by government. You know,
Absolutely.
a number of magistrates in the wake of the Obergefell decision have done exactly that. They've resigned. I don't know what the numbers are, but I know it's in the dozens from what I last heard. And when each one of these folks resigned, I thought, why don't you guys just stay and fight? I mean, there's an Oregon judge, I don't know whether you've heard about this guy or not, that is absolutely fighting. He's established a legal defense fund because they know they're going to come after him, not just as a judge, but probably also as a member of the bar, because he's refusing to do gay marriages because it violates his conscience. And you know, he sees it as his duty to fight. And I encourage everybody that's out there, anybody that's listening here in Alaska, and I'm not sure of any judge here in Alaska that's raised religious liberty issues, not heard of it. I'm sure that there probably are some, but it is necessary that we not just turn over and say, you occupy the field, I'm going to resign. Rather, you do have a duty to...
Well, I agree. And I might add, too, that as far as the judges, when they perform marriages, I don't know about Oregon, but in most states, judges may perform marriages they don't have to. And so a lot of judges, rather than resigning, have just said, well, I'm not going to do any marriages at all.
So what's your suggestion about what we should do in the face of, at least in this area, this assault on religious liberty?
I think we should be encouraging officials at all levels of government to disregard this decision, to declare that it does not apply in our county, it does not apply in our state. And yes, that could involve some confusion, but I think the other alternative, to say that law is nothing but what a majority of a 9-person committee of lawyers who are unelected and hold office for life, that law is simply what a majority of that committee decides it is, I think that's a lot worse. That is a lawlessness in the nth degree.
And it's a terribly unrepresentative group of people, too. I don't know whether you saw Justice Scalia's comments the other day. He gave an address, Constitution Day, at a college this week, where he said, if you look at the composition of this court, all but one are from areas outside of the South. So geographically, you don't have diversity. Of course, they all come from the bar. I mean, there are all sorts of different things that cause them to be exceptional as far as whether or not they are truly representative. But more importantly, they see themselves as a law unto themselves. They don't see the Constitution as a limiting impact, with the exception, of course, of 3 or 4 of the justices.
Right. They're not even representative of lawyers.
Yeah.
Every one of those justices is a graduate of either Harvard or Yale. That's a tiny minority of lawyers. 6 of them are Catholic, 3 of them are Jewish, no Protestants, no evangelicals. You say no real Southerner, no Westerner, if you don't count California.
Yeah, just extraordinary. Well, I appreciate the work that you're doing, Colonel Eidsmoe. Look forward to hearing you at the Freedom Conference in Des Moines on November 6th and 7th. If you're a listener, you want to join us there, go to www.freedom2015.org. You can register, get a discount if you type in Miller at the promo code. Should be a great couple of days there. We'll be broadcasting the Joe Miller Show from Des Moines during those 2 days, and we're going to give away a few registrations as well. Listen to the show. We'll probably be doing that within the next several weeks. Colonel Eidsmoe, thanks again for being with us.
Thank you, and I look forward to meeting you there and love to come up and ski at Mount Alyeska again someday.
Sounds like a winner to me. Thanks again. Stay with us. The Joe Miller Show right back after these messages.